Most Jamaicans do not have a will, and if you do not have one, I hope that by the end of this video you will make preparations to draft your will and to begin making your estate planning strategy. Now, a will is something that everybody should have. However, I believe that it's a document that you should have, but make preparations to not have to use. And I'll explain what I mean. Disclaimer, this video does not constitute legal and or financial advice and is for informational purposes only. Feel free to consult your attorney or your licensed financial advisor for further information. Now, a will is a document that outlines your last wishes and how you want your assets to be dealt with upon your death. If you die without a will, you will be held by the state to have died intestate, meaning without a will, and that's where the laws of intestacy will kick in, where the government will have to locate or ascertain who your next of kin is. That can be spouse, children. In the event that you don't have a spouse or children, then your parents, grandparents, and their different rules that govern intestate situations. The aim of any good succession strategy is to pass on the subject assets with the least amount of fees to the beneficiary that's receiving said assets. So we want to avoid hefty probate fees, hefty tax implications, so on and so forth. So a good estate planning strategy accounts for all of this and then seeks to determine how they can pass on these assets with the least cost to the estate. Now, the first thing I will say is life insurance. Life insurance policies are not typically subject to a will, meaning this is an independent contract which your beneficiaries can present to the insurance company along with IDs for themselves to identify who they are and a copy of the death certificate, and they can typically get a direct payout from this life insurance policy without having to go through probate to get access to that. So it's a direct payment from the policy. If there are any assignments on that policy, so say for example you have a mortgage and that policy is assigned to the mortgage, then what the insurance company will do is clear the mortgage on the property and then pay out what's left from those monies to the beneficiaries. If there are no assignments, the full value of the insurance policy gets paid out to the beneficiaries. And this is something that your estate can get access to without having to go through probate. Now, secondly, I will say your investment and your bank accounts. If you are the sole person on your investment and bank accounts, then these accounts will have to go through the probate process because it's legally in just your name. Now, when you have a will, you can direct how you want, percentage-wise or whatever, your investment and bank accounts to be dealt with, and this goes through the probate process and is subject to the associated fees that come with that probate process. So court fees, attorney fees, all of that. Whereas if you add persons to your investment or bank accounts, that person that you add has a legal claim to those accounts. There is definitely a trust factor here because while you're alive, they also have a claim to your accounts. So you can do with that information what you will. But what I will say is if you have minor children, you can also add them to your investment and bank accounts so that they can have a legal claim to that asset without having to go through the probate process. Because one, there is a time delay. So if you die today, it can take months and sometimes even years for them to get access to the funds in your account. And if you were the sole provider for your children, then what's going to happen to them in that time period between when you die and when they actually get access to those funds? Like, there's a lot of in between. So if you can reduce that time gap and reduce the cost gap, because if you had 100,000 in your account, fees are going to come out of those monies for probate associated fees, attorney related fees, and your child is not going to get, or children, whoever your beneficiary estate is, they're not going to get the full amount. It's going to be whatever amount it is, less the fees. So if you can avoid that altogether, then why not? So I would say add persons to your accounts. You do not need to be the sole person on the account. Yeah. What I also think is wise is to have a supplemental form to your will. So it provides a little bit more context to, not to the courts, because the will is the final document that states your wishes, but it can provide some additional context to your beneficiaries. So in that supplemental document, it doesn't have to be anything, you know, too serious. It can just be a letter that you write to them, and in that letter you can state your passwords to, you know, probably email address, or your banking login details if they are on your account, so that they can access your accounts. Because it's one thing to add them, but it's another thing to actually make them aware of the fact that they're on the account, so that they can then access it. Because it makes no sense to add them, they don't know, you pass, and then they have no knowledge whatsoever that they have this account with their name on it, and they can lay claim to it. Yeah, so that's definitely something that, you know, you can do. If you don't have kids, it can be, you, when it comes down to estate planning, you have to assess your circle. Who do you want to get your assets when you pass? That's the first thing. So when I say yes, there's a trust factor, there is, but I really swear for people and say, oh, this person is not going to do this, not going to do that. But you can weigh the pros and cons and say, okay, I want my sister to get access to this, and you will add her on your account. That can be a deterrent for some persons because they're worried about theft of their assets. But as the Bible says, everybody has to work out their own salvation with fear and trembling. So you will have to assess how you want to set up your estate. If you are scared and you think that persons are going to steal your money while you're living, then by all means have your will capture all of these things so that it can go through the probate process. But there is a way for you to avoid that probate process when it comes down to your investment and bank accounts. So you just have to weigh the costs and then establish what estate planning strategy is best for you. When it comes onto the realm of business now, you can do a business continuity plan that outlines what happens upon your death. And this can be as simple as your death triggering a shareholder meeting where you would have had an advance directive that outlines how they're going to handle your shares, or if it's a case where they're going to issue new shares to your beneficiaries, your next of kin. These are things that you can draft before in your business continuity and business succession plan that can kick in once you die. Now, the other option, if it's a smaller company, and I am referring to a limited liability company, LLC, in the States, they have C Corps, S Corps, all of that. I'm not referring to a sole trader because there is no succession for a sole proprietor. Sole proprietor, that ends when the person dies. So there is no continuity there. If you have a limited liability company, then there is the chance for succession planning. So in situations like that, if you have a small company, meaning it's just you and maybe one other person, and you don't have like a group of shareholders or stuff that's gonna, you know, meet and all of that stuff, what you can do in situations like that is add your children to your company as a shareholder, as a director. And director, I want to also outline that the real claim and ownership stake in a company is when the person is a shareholder. A director is an appointed function that can be removed at any time by a vote of the shareholders. So when you are adding your children to, you know, your company, it should be first and foremost as a shareholder, so that they have some ownership in it and can deal with the company as an owner versus a director. So you can add them as both. But the most important thing is the shareholder, because that's where the ownership lies. So that's one thing. So in the event that you die, and we know the Bible says that it is appointed unto man once to die. So death is certain. It's coming one day, right? When that time comes, they do not have to go through a probate process to deal with the company, and especially if it's depending on the nature of the company, where they might need access to the company funds to sign off on documents and all of that. To ensure proper flow and business continuity, it's good to add them as shareholder and director, so that they can be recognized by the bank if they're signing any documents, signing off on checks, if they need to make transfers, make certain payments. They need to have all that information so that there is no gap in business operations. Because also, depending on the level that the scale that the company is on, if you have staff and all of these things, when payday comes, how are they going to pay the staff if they don't have access to the company accounts and stuff like that? So all of these things, you have to really think ahead and then create your estate planning strategy so that everything can run smoothly. A good estate planning strategy is one that runs smoothly and does not cost the estate a bag of fees. Another thing is real estate. Now, there are different levels to estate planning, and we have trusts and different vehicles that we can use. But the most rudimentary level thing that we can understand when it comes on to real estate is that there are two types of interest in property. We have the joint tenancy and we have the tenants in common. Now, with the joint tenancy, there is automatic succession. So when one person dies, ownership goes to the other person. Whereas for tenants in common, you have a predefined interest in that property. So, for example, John and Jane have a property and they have 50% interest as tenants in common. If John dies, John's estate can and does have an interest in that 50%, and this would have to go through the probate process for the court to determine, how that's going to be dealt with. Whereas if John and Jane had a property as joint tenants, when John dies, succession ownership goes directly to Jane, just automatically. The only thing that's needed is a notation of death, and that's not something that even has to be done immediately. It can be done at the point in time that you want to deal with the property. Meaning, if you plan to sell the property, you have to, make that notation of death on the title before you can transfer that to the intended beneficiary. But if it's a case that you probably don't have the money to, do the notation of death, it's not something that's like immediately pressing because your name is already on the title. So you do have that, ownership in it. And if you have the death certificate for John, along with the fact that your name is already on the title, then depending on what you're doing with the property, then that can sometimes suffice before if you don't have the time or the funds to do a notation of death on the title. All right, when it comes on to motor vehicles, so again, though I hope you get the gist of everything that I've been saying, is to share your assets so that once the assets are shared, it eliminates the whole probate process. So if you have a motor vehicle, you can add someone to the title, someone you trust, someone that you would want to have access to the vehicle if you die. And again, this is just the most rudimentary level. There are ways, because I know there is a trust factor, so there are ways to structure different things and different assets in trusts so that you can control how assets are dealt with while you are living, and also stipulate how it's going to be dealt with when you die. So there are different vehicles that you can use, but at the most fundamental at the most fundamental level, something that's easy for you to do when you're purchasing an asset, add a trusted person to the asset as well. Yeah. So that's one thing, because let's say for example you're a parent and you purchase a vehicle, you can add your child to the motor vehicle title, because if you die, your child does not have automatic access to your asset just because it's yours. It will have to go through a probate process, and if you don't have a will, it will have to go through, an administrative process by the government using the laws of intestacy. No, if you die, again, they can't have access to it, because to get insurance and all of those things to deal with the vehicle, they would have to be on the title. And if they're not on the title, that prevents them from, dealing with the asset as they would like. So if the insurance expires, then basically they can't use the car because they can't renew. Whereas if their name was on the title, then they could deal with the asset even after you pass. So, that's that. I think I've basically touched on like a general overview. Again, this is just the fundamental level. There are levels. There are levels to estate planning and succession planning. So if you learned something from this video, please like, comment, share, and subscribe. If you have any questions and you want me to do like a follow-up video, then I will, because I have a bank of information in my head and I am always happy to share information. The Bible says that we perish because of a lack of knowledge. So any information that you can get access to process and use it to edify yourself is good. So you can check the link in the description box if you want more information, and thank you so much for watching. Bye.